Welcome to our 5-part series covering the legal aspects of association law for both homeowners and condominium associations in the state of Georgia. Our law firm is highly experienced in the area of association law, and having represented many different associations, we've seen just about every challenge that can arise for a board of directors to deal with. And our experience in all these areas can serve to guide the board in the best manner for the association as a whole. So in this series, we'll provide a comprehensive guide covering the legal responsibilities of homeowners associations, HOAs, and condominium associations under Georgia law. And it will serve to educate board members on the vast many topics of legal compliance and the various rights of the association, the board members and the homeowners. And I'll talk about the role our law firm plays in supporting the association's need in every single area. And in each part of the series, I'll focus on key legal issues faced by associations on a day-to-day basis. And I'll follow that up with many practical situations and solutions, and how the association lawyers that are part of our law firm can guide the board in all of these areas in the most cost-effective way. So in part one of this 5-part series, I'll cover the subject of delinquencies and delinquent assessment collection, starting with the key objective of this part of the series, and that is to educate the board on the best way to handle delinquent assessments. And that's from years of expertise in this area. The legal process for the collections, and how our law firm can manage that entire collection procedure of minimizing delinquent accounts and securing timely payments in the most cost-effective way for the association and its own budgetary needs. Some of the key topics I'll cover in that part one are the importance of assessment payments, including the role of assessments in maintaining the association's financial health, and the consequences of delinquent payments on the community. For example, budget shortfalls, maintenance delays, etc. And I'll outline various legal tools for delinquency management with a review of Georgia laws governing HOA and condo association collection rights. Specifically, Official Code of Georgia, Title 44, Chapter 3, Article 3 for condo associations, and then Title 44, 3.6 for HOAs, which is technically referred to as the Georgia POA, the Georgia Property Association Act, and the main purpose of that act, which is to strengthen the HOA's ability to collect money with fines, liens, interest, attorney fees, and the foreclosure process and everything that's covered there. I'll talk about best practices in the collection process, starting with the initial steps of notices and demand letters, and we'll talk about our experience on what works best in each situation. I'll cover collection strategies, payment plans, late fees, interest, and then the legal recourse of filing liens, garnishments, and lawsuits in particular situations. I'll outline best practices for the boards by providing policies and procedures for handling delinquencies, and the importance of consistent enforcement of rules. And then lastly, in part one of the series, I'll talk about how our law firm supports the association with customized collection plans based on the association's needs and what makes sense, and what makes sense for them on their own individual budget that they're dealing with. the regular monitoring of accounts, and then reporting to the board, and then legal representation in court, or mediations or other collection efforts. And then finally, I'll cover fee structures, whether a contingency-based option or a flat fee or a reduced hourly rate for collection services works best for your board. And then most importantly, I'll talk about how all of these legal fees can be passed on, or in many instances just collected directly from the person who should be paying them, and that's the delinquent homeowner. All right, part 2 of the series is going to cover the association's governing documents and board of authority. So the objective of that part is to explain the legal significance of governing documents and how to ensure that the board operates within its proper legal authority with its rules and the decisions that they're going to be faced with on an ongoing basis. The key topics there are going to be the importance of the declaration, the bylaws, the rules of regulation, amending your governing documents to meet the changing needs of the association. That's something our law firm does often as the needs change for our client associations. I'll talk about the legal limits on board authority, and I'll give examples on many various situations you'll likely be dealing with. And then finally, I'll provide a framework for dispute resolution within the community. Our law firm has developed a very cost-effective method for these inevitable disputes to be handled that I'd like to pass on to you. Part 3 is going to cover contracts, vendors, and liability issues, with the objective there being to provide guidance on drafting and negotiating contracts with vendors, contractors, or service providers, and then how to manage your liability risks there. The key topic of that part, among others, is going to be the essential elements of a contract under Georgia law, vendor and service provider agreements, risk management, and then some of the indemnity clauses that you'll see. And then lastly, I'll cover an overview of the role that insurance plays in every aspect of associations' operations. Part 4 will be the critical area of enforcement, enforcement of covenants and rules and regulations, with the objective of that part being to help the board understand how to enforce covenants and rules while they stay compliant with Georgia law, and to avoid any legal challenges that come up. Those key topics are going to be legal authority of the association board, a management company legal authority to enforce the rules that you have into place, fines, penalties, and even the suspension of privileges. Handling disputes, legal challenges that come up day to day, and then lastly, I'll touch on fair housing compliance and avoiding any discrimination claims. And then in Part 5, the final part of the series, I'll outline dispute resolution and litigation, with my objective there being to educate the board on the entire legal process in a nutshell, and how to decide if a lawsuit would be beneficial or just a waste of resources in a particular situation. The key topics there would be mediation, arbitration, or other alternative dispute resolution methods, common areas of litigation for associations, contract disputes, or even personal injury claims that can happen on the property. And then lastly, I'll cover in detail how our law firm can represent the association in litigation of all types, with examples, many common situations that occur that the board can easily make a decision on the best way to handle these matters in the most efficient way possible. Now, so as you can see, my objective of this series as a whole is to provide a framework of reference for the board members of of every association in the state of Georgia, both HOA and condominium, so that they can be better educated on the most common areas of association management. This understanding will then allow each board to focus on the most important task that they have, and that is maximizing the efficiencies of their own association for budget purposes. And if the board is efficient in its management of these matters that we all talk about, there's no doubt that's they're going to inevitably arise. Then they can handle them in the most cost-effective way, and those savings can then be redirected to the further growth and the value of the property.